時間到啦。
Members, it's the appointed time and we have a quorum. We first invite the administration in. I remind members that if any declaration of interest is needed, you may do so. Per Rule 83A of the Rules of Procedure, I declare my interest. My company operates hotels. Chairman, I'm an independent non-executive director of a listed company, and as I know, the group also operates hotels. Any other declarations? I'd like to welcome the administration. From next meeting on, I would not introduce the officials one by one. And with us today, we have Mr. Jack Chan, Under Secretary for Home Affairs, Ms. Viga Wong, Deputy Director of Home Affairs, Ms. Grace Lee, Assistant Director of Home Affairs, Mr. Peter C., Senior Assistant Law Draftsman, and Ms. Carmen Chu, Senior Government Counsel from the DOJ. Welcome. We had a meeting on the 6th of November last year where members raised questions and the government provided a written response. I'd like to invite the administration to offer an overall response to the issues raised. Thank you, Chairman. Once again, I'd like to thank all members of the Bills Committee for raising a number of views on the Hotel and Guesthouse Accommodation Amendment Bill 2018. We realized there were two main issues of interest. Under Secretary, are you going to address views raised in the hearing as well? We are looking at two papers. First, a response to the issues raised on the 6th of November last year, as well as a response to issues raised on the 4th of December during a public hearing. After that, the floor will be open for questions. Under Secretary, we realize that members had a few main areas of concern. First of all, the bill has introduced a strict liability offense, and if the relevant premises are used as hotels or guest houses, the owners or occupiers would be held liable. Some people felt that this might be too strict and unfair to owners. The objective of introducing a strict liability offense is to tackle the difficulties in collecting evidence due to the different modes of operation of accommodation, and these mainly target the owners or tenants. We also introduced statutory defense so that the relevant owners and tenants can offer a defense, for example, by claiming that they were inadvertent, or that even with due effort they could not prevent the premises from becoming a hotel or guest house. And our principle is that prosecution can only be taken with sufficient evidence. Another issue is the enhancement of the licensing regime. if according to the deed of mutual covenant or land lease that a premises can only be used for residential purposes, then a license cannot be given to the premises. Some members were concerned whether these measures would lead to difficulties for operators to continue to operate. As we said, these are not new requirements, and all along, applicants for hotels and guest houses have always been required to comply with these requirements, and applicants all along have had to comply with these requirements. If an injunction is issued due to the operation of the operators, or if the operation of a hotel or guest house is against the land lease, we might rescind the relevant license immediately. The licensing authority has to consider the relevant documents, and this is a respect towards the spirit of the contract, and this can effectively minimize disputes and minimize the need for matters to be taken to the court. Some members also raise that a separate control regime is needed for homestay lodging. I stress that the current and proposed regime under the Hotel and Guesthouse Accommodation Ordinance is already flexible. It covers different types of hotels and guest houses, including holiday camps and holiday flats. Even though we do not have a separate regime to regulate homestay lodging, the licensing authority has always adopted a flexible approach in imposing control on various types of accommodation, and these are tailor-made for different types of premises, and they are proportionate to the scale and mode of operation of the respective premises. We have established appropriate licensing requirements for different premises. Hotel licenses are different from guest house licenses. Guest houses are subject to less stringent requirements. And with regards to the operation of holiday flats, we have established a set of or a guide to license application for holiday flat. Many village-type houses in the new territories are able to obtain a license to operate small-scale guest houses. The HAGAO specifies different requirements for different premises, and this is in line with the control regimes elsewhere in the world. A detailed comparison can be found in the paper, and as usual, we would adopt a pragmatic approach when we deal with the license applications. Myself and my team will continue to listen to views from members and address members' concerns. We hope that the bill can be passed as soon as possible to improve the control regime on hotels and guest houses. The floor is now open for questions from members. 5 minutes each. A division has been claimed for another meeting, so I would go first. As for the strict liability offense, in the past, circumstantial evidence would be adopted as a form of evidence, but this wasn't mentioned in the paper. The paper only mentioned strict liability. So what is the connection between the strict liability offense and circumstantial evidence? does some absolute liability already cover circumstantial evidence? As for the enter and search warrant, a warrant can only be applied if there is enough evidence. For many unlicensed guest houses, they might be residential premises. So if you are not able to enter, how can you secure the evidence needed to apply for a search warrant? This is a chicken and egg problem. How can a warrant be secured from the court? How can a legitimate warrant be secured? Thank you. The strict liability offense and circumstantial evidence actually go hand in hand. Under our existing provisions, the operator involved must be caught red-handed, and that is the money must be paid face-to-face. This has created a challenge in collecting evidence because with internet transactions, a face-to-face transaction might not always take place. So for the proposed strict liability offense, so long as we can prove that a premises is being used as a guest house, and this involves circumstantial evidence. For example, during the course of collecting evidence, we might find leaflets or advertisements online promoting this guest house, and we might see a large number of people entering and leaving the premises. So these are circumstantial evidence showing that this premises is a guest house. And we might also check the address of the premises, and we can see whether it is licensed. So these are all forms of circumstantial evidence. If we need to conduct a search and see any items that suggest it is a guest house, then it is also a valid piece of evidence. Under the strict liability offense, the owner or tenant is also liable unless they can provide a defense that they do not know about the situation, or that they could not prevent this from happening. As for the search warrant for residential properties, apart from enter and search operations, we also collect evidence via other channels. And from the internet, we would know the premises which are currently utilized at guest houses, and we would apply for a search and warrant accordingly.
Let's ask you about covered operation. If you mount a covered operation but you do not have a warrant, can you do so? According to the present law, we do not need any search warrants. In reasonable circumstances, law enforcers can enter and search. But the difficulty is people just don't open the door, and you cannot gain entry. In the bill, we can have a search warrant, and even if the other party is non-cooperative, we can use reasonable force to enter. But now, we don't need a warrant for covered operations. What about in future? Do you need a warrant for covered operations? Well, it will be better. In future, we don't need to mount covered operations because we have strict liability. We do not need to have all kinds of evidence. As long as we can see circumstantial evidence showing that there is no license while a guest house is operated, well, unless the owner can advance a defense, he will be liable. We believe there will be little necessity for us to mount covered operations, but still there will be some. Yes. What is the legal backing for this? Well, yes, of course, there is a legal basis for this, but still we won't need a warrant. Next, Mr. Kwok Wai Kang. Thank you, Chairman. Last month, we had a hearing. We heard many different views. All in all, there were 3 categories of views. One, from the hotel and guest house industry. Well, actually, the views are quite different between hotels and guest houses. Number 2, building management people or owners corporations. And 3, views from members. From the hearing, I heard certain issues which I'd like to hear more on. First, owners' representatives said that owners would be held liable if their property is rented out for the operation of unlicensed guest houses or they flout the DMC. And the question was, would there be any assistance for owners to take back problematic units? Say I rent out my unit, I didn't know it would be used as a guest house, but now I know. The owner and the operator would be prosecuted, but would there be any package of measures to assist the owner? Say, now I find out that you are operating such a guest house and I want to take back the unit. Can he do so? Secondly, the independent committee. The applications that will come in will span over all 18 districts. Will there be one for every district or just one for the entire territory? Is it that every time you will summon the district officer of that district, because you said that the district office will play an important role? So will there be many panels or just one panel? And what about the composition of the panel or panels? Do you have any rough idea now? Undersec. Okay, 2 questions. Number 1, to assist the owner to take back the unit. We can talk to the relevant bureaus or departments, but we must respect the contractual spirit. If the owner and tenant have an agreement between them, should we intervene? However, we will definitely take enforcement action, and if the owner needs help, we can look into that. Secondly, the independent panel. Our thinking is that after passing the bill, we will set up this advisory panel, and we will have a group or panel of advisors, and they will come from different sectors, including the legal sector. Some of them may be surveyors, architects, and there may be people from the industry. There will also be district councillors. I believe we have not threshed out the details. I don't think we will set up one for each district, but it is a panel that will be set up, and where necessary, we'll select people from the panel in order to hear a particular case. And we will, of course, ask people to declare interests. If it involves an application from a certain group of companies to which that person belongs, then this person should not be on the panel. This is the same or similar to other licensing regimes. Well, the panel, as said, would include different categories of people. And if there is a case from a certain district, you will select people from the panel. Does it mean you will have a very long list of panel members, say like 100? And you will have regard for the case in question and the district it is in, and then you will select 10 people to hear the case. Is that right? No, there won't be many people. We'll have a pool of members. We'll select a few every time. You said you would want to include district councillors. There are over 400. How many will you include? We will use the established system in order to appoint suitable people. District officers will have a role to play. when views are gathered, we will consult the DOs. If you invite councillors on a personal basis, they will welcome it, but it's difficult to include every councillor. I would say the district officers would have a big role to play, and I believe the DO should be represented on panels which hears a case of that particular district, because the DO will be reflecting views. We agree. But the panel members will not be official members. The DOs will only help with the consultation. Mr. Tony Jia. Thank you, Chairman. At the Bills Committee, before this one, we asked about manpower. On the 16th of January, when you answered us, you referred to this. Paras 18 and 19. I understand that at the beginning, you might need people to tackle extra work after the bill is passed, and therefore you need extra manpower, but then it will level off when things get established. I'd like to ask you whether you will just reduce the amount of manpower that is increased just for the passing of this bill. I understand that at the authority, there are 150 full-timers and 50 part-timers. You say the manpower will be leveled off. What do you mean? Does it mean that you will keep the present contingent? In fact, you have certain part-timers, and what will happen to them? Secondly, the industry is quite concerned because under the bill, you will be introducing procedures. You will review and improve certain projects. You will inspect those. And then the licensing timeline may be lengthened. As you know, in December 2017, the Director of Audit said that the licensing period took 357 days to 469 days in 2012. Well, you have taken a year or over a year to issue a license. I don't think that is your target timetable. Meaning you have exceeded your own timetable. After the bill is passed, what is the target timetable for issuance of license? And secondly, the industry is worried because if you drag on for so long before a license is issued, it will be very difficult for their operation. How can you facilitate the issue of license? And if you say it's not possible, it's because of the long procedures. And then will there be suitable measures to help them under SEC? Thank you. First, manpower. As we said in the paper, we believe that the new system will mean additional work and also less work for our manpower. This is because the new measures would mean that we will have to look at the land lease, the DMC, and also consult the districts. More people will be needed, and then we'll have the independent advisory panel, and therefore we might need more people to do vetting. Right now we have over 140 people who are dedicated to licensing. Many of them are professionals like building surveyors, and also officials from the FSD. Now, where can we save manpower? This is because when we introduce the strict liability scheme, as I said, we might not need to mount so many covered operations. We might have to knock on doors many times nowadays, but later on we can have a warrant, and then we can use force to break open doors, and it will make things much simpler. Chairman, I understand that. Well, this is already in the paper. I'm asking you about the final situation. Will there be more people or fewer? We just want to know. Well, I want to know that as well. We have to wait till the bill is passed. We don't have the new system yet. We'll be very prudent. in watching the situation, and we can have flexible deployment of manpower. If necessary, if we need, we will add manpower according to established mechanisms. Dr. Chair mentioned the 50 part-timers, but they are usually law enforcers. We cannot engage full-timers because when you have covered operations, you have to have new faces. You cannot afford to have people know that you are doing enforcement action. Therefore, we do need part-timers. What about the licensing timetable? Okay, the target timetable, we have done some statistics. Actually, in 90% of the cases, it's because the applicant has not complied with all the requirements. And in fact, we have only taken up 10% of that time. In other words, we have taken up 10% of the 300 odd days in order to issue the license. In 90% of the time, it's because the applicant has not complied with the requirements. But what about a target timetable? Maybe you have requirements on projects, etc. To the industry, they know that you want to put things back on track, that everything will be regulated so that we have regulated facilities for tourists. But you must have a timetable. You can say you work fast, but very often you impose requirements, and you have to think about how things can be compressed. Well, if you say the applicants want to postpone things, but I don't think that will be the case because, like restaurants, there is no reason they want to drag their feet because they are paying rent and they are paying the price. So procedurally, if you can clarify things and simplify matters, it will be good, and I believe you should have a target timetable so that we know whether you have achieved the target. There is already an increase of 31% between 2012 to 2017. Will you take actually 2 years to issue a license? That would be too late. Understand? We have performance pledges. Say, after receiving our application, we would issue a reply with a certain timeline, and we would conduct inspection by a certain timeline, and we will not drag our feet. And we are not accusing applicants for dragging their feet. It's just that they do not comply with requirements of building safety and fire safety, and that is why time is needed to allow them to comply with requirements, and we are assisting them. But the responsibility is on the applicant. If they do not comply with the requirements, we cannot issue a license. I hope you will clarify the guidelines, because if people don't understand them, you will be wasting resources, and then people will also be aggrieved. It does nobody any good. Do you have clear guidelines? Yes, we do. Every time, well, let me say this. After every inspection, we will give a promise as to within how many days we'll reply them what should be done. Say we need them to widen the access. We need them to enhance the fire resistance ability of a door, and how many fire escapes there should be, and what is the illumination for the fire escapes. They just have to follow them.
或者咁嘅謝員，如果你
Mr. Chair, if you have further questions, please wait for the next round. Next, Ms. Elvin Young. Thank you, Chairman. On homestay lodging, the government has offered a detailed written response, but there are a few areas I want to raise. The government said that they are being more lenient compared with other areas under the existing laws of Hong Kong. The jurisdiction of Hong Kong does not define homestay lodging. The more lenient conditions apply to guest house that are holiday flats. When we look at Taiwan and Japan, they have specific sets of laws as well as licensing regimes for homestay lodging. No one said we are going to compromise safety or fire safety requirements. But apparently, the government did not consider the fact that Hong Kong lacks a definition for homestay lodging. So I hope the Secretary can tell us whether the government would offer a clear legal definition for homestay lodging. Homestay lodging is very different from guest house holiday flats. And even the concepts of hotels and guest houses are not very clear. So by offering a clearer definition, you can better protect customers. Thank you very much. We had ample discussion on this issue in previous meetings. The government's stance is that there is no current need to legally define homestay lodging or introduce a separate regime. Through the hotel and guest house licensing regime, we allow small-scale family lodging to operate, and we feel that they can be dealt with under the existing regime. But for owners and tenants who let out their vacant room for a short period of time, we feel that this is not in the interest of Hong Kong. And as I said in my opening address, we are happy to look at the specific cases one by one. Of course, we have requirements in place, but so long as the requirements are met, they can be given a license. I don't intend to dwell on this issue, but I want to express the view that the government's stance is not conducive to the existence of different modes of operation in Hong Kong. Structural safety and fire safety are things we cannot compromise. But apparently, from what the Undersecretary just said, the government does not intend to open its doors for homestay lodging. As it stands, the door is firmly shut. In this respect, the government should explore what they can do. Should there be long-term plans? I think this is something the government should think about. Thank you very much. We have noted your view. We will certainly keep tabs on the global trends and see how they might apply to Hong Kong. Mr. Ko Wai Keung, thank you. We have been discussing the issue of circumstantial evidence and whether it would be conducive to law enforcement. I'd like to follow up on that. If someone offers their premises for letting online, would that constitute sufficient circumstantial evidence for a enter and search operation? According to the paper, the enforcement officers can exercise appropriate force in entering the premises. So I'd like to know what is meant by appropriate force. So would the officers simply have to say that they intend to enter, or would they break inside the premises? So that is my second question. The third question is whether the regime would become ineffective due to a lack of power. How can you allow the enforcement officers to properly carry out their work? In terms of circumstantial evidence, online promotion could be one of the forms of circumstantial evidence. We do have officers who monitor websites that offer premises for rent. If we see that operators promote their premises without a license, this is something we would monitor. We would also post our disclaimers or warnings on those websites to remind customers to stay at licensed premises. As for entering premises by using appropriate force, we are not the only authority. The building department would also do the same. But as to what defines appropriate force, our officers would attempt to avoid physical contact. Would the officers break in, and our officers might force their way into the premises by breaking the door locks? How can the government ensure that enforcement will be effective? Would you become a toothless tiger? After we introduce strict liability offense, enforcement will be much more effective because we can secure an enter and search warrant. We have also raised the penalties, and if needed, we can apply for an injunction from the court to bar the premises from operating for 6 months. Chairman, after the ordinance is amended, some premises can still continue to operate at appropriate venues, even if they are licensed. Due to poor conditions, they might create nuisance for other owners in the building. Operators are unlikely to stop accepting guests to facilitate renovations, and this would bother other owners in the building. Would the government encourage the owners to urge these hotels and guest houses to rectify their problems? Thank you. We are dealing with the licensing regime. As for water, seepage, and other issues, they are another issue altogether. If during area consultation some residents tell us that there are issues including water seepage, we would urge the license applicants to carry out the necessary work. But if there is an issue of water seepage, we might refer the cases to the relevant department, but we would still offer support. Chairman, the Undersecretary should promise that such factors would be considered during license application. Undersecretary, this will likely be the case because let's say if we have a guest house that is seeking a renewal, if there is water seepage, there would be a lot of objections from the residents or complaints filed towards the independent panel. So now it's my turn. The Undersecretary said that for holiday flats, you would be relatively lenient considering the geographical conditions and designs of these flats. Can you give us any figures on the applications from holiday flats and how many applications were successful, etc.? When you consult residents in the district, well, this would be one of the factors to consider when you decide whether to grant a license. Are there any administrative guidelines to clarify the relevant criteria? That way, the views of the residents and relevant stakeholders can be accurately reflected to the panel. Or else there might be bias when you make the decision whether or not to grant an application. For holiday flats, the criteria are less stringent than those for hotels and guest houses. For example, for flats less than 230 square feet, no sprinkler system is necessary. As for the number of successful applications, we can look up the numbers, but very often, for most cases, they would eventually succeed because we would provide support to the premises. We would, so long as an operator intends to run a proper guest house in Hong Kong, we would offer as much help as we can. As for the administrative guidelines, they would be drawn up later after the panel is set up, and we would have guidelines in place to govern how we deal with the views. Even with objection from residents, it does not mean that an application will be rejected. As Mr. Kwok said, even if there is water seepage, so long as the applicant can overcome the problem, a license can still be granted. I'd like to talk about paragraph 28 from your response. As agents or agencies or someone who inadvertently promoted unlicensed hotels or guest houses are not considered to be operating, keeping, managing, or having control of the licensed hotel or guest house. I see that on a lot of websites, they are recommending certain guest houses or unlicensed guest houses. So in terms of criminal liability, would these intermediaries be held liable in the future? I would defer to Ms. Wong. According to the existing legislation, under Section 5, a person commits an offense if the person operates, keeps, manages, or otherwise has control of any premises that is a hotel or guest house with no license in force. So whether or not the promotion of the accommodation is deliberate or not, based on the current legislation, they are not the targets we intend to control.
We like to enforce the law on the premises, and therefore there must be operating, keeping, or management. The new clause is about strict liability as we discussed it, and it will be extended to owners or tenants of unlicensed guest houses. Therefore, if you just do referral or introduction on websites, as we said in para 28, we'll have to look at the individual circumstances. If it is just a referral or acting as an intermediary on the website, these will not be targets of enforcement. Well, of course, you can say that it was inadvertent advertisement. Whether it is inadvertent or deliberate doesn't make a difference. Well, if it is on a website and it's just a kind of introduction or referral, we have to, of course, establish the role of the person in order to interpret it or extend it to such an extent that there will be the elements of operation, keeping, or management. And it depends on individual cases. I was saying that if it is purely a referral or introduction, and if there are not these elements of crime, then they will not be targets of enforcement under this bill. Any other questions? If not, we will go to the next part. Our legal advisor has raised certain views, but they cover a wide range of matters. I will not discuss them now unless members would like to ask certain points in the legal advisor's paper. If not, we can visit them when we do clause-by-clause examination. If members do not object, we can go into clause-by-clause examination. Shall we do that, Under Secretary? Can we start? Chairman, let me give an introduction on the framework of the bill. Thank you, Chairman and members. We'd like to thank you again for your valuable views on the policy direction of the bill. Before we go into clause by clause, I'd like to give an overall introduction of the framework of the bill. There will be 5 parts. First, the introduction. Second, amendments to the principal ordinance. And then parts 3 and 4, relative amendments to related ordinances, and then part 5, the amendments to other ordinances. Part 2 is the most important part, and the main clauses are Clause 9, the introduction of the strict liability offense. If it is a guest house or hotel but there is no valid license, then the owner or the tenant will be held liable. Clause 10 and 11 have to do with the new requirements of the improved licensing regime, including the empowering of the authority to inspect the DMC or the land lease to see whether there are restrictive clauses, and also views of affected people. Clauses 12 and 13 state appeal against decisions of the authority. Clauses 14 to 17 include new amendments in order to empower the authority to apply for a warrant from court in order to go into suspected unlicensed hotels or guest houses, and in certain cases with force. And then clauses 18 and 19 empower the authority that if the same premises have been convicted for 2 prescribed offenses within a period of 16 months, then an application can be made to the magistrate in order to close the premises for 16 months. And then clause 28, transitional arrangements, that is, within the transitional period of 12 months, the authority can make use of the existing licensing regime after the bill is passed in order to renew existing licenses for a period of 12 months. And after the transitional period is over, renewal applications will be considered under the new regime. If the bill is supported by the LegCo and passed, the SHA will gazette the designated commencement date and also the 12 months transitional period, which will start on the same day. Chairman, we will be happy to give more detailed explanation of the bill, and we welcome views on the details of the bill. We will continue to work alongside members in order to respond to members' concerns. Ms. Wong, will you take us through the bill? Deputy Director. Yes, Chairman. Let us now look at the bill. Just now, the Under Sec has already given an overview of the layout of the bill. Let us now look at Part 1, the introduction. We have included the short title and commencement preliminary. Any questions? No questions? We can carry on. Part 2, amendments. Long title. We are going to make an amendment to the long title in the Chinese text. It doesn't change the original intent of the existing law. We are just changing the wording in Chinese. Yes? No questions. And then Part 1, preliminary. We have repealed the entire section on interpretation. This is because we have new clauses in the bill, and therefore we need the interpretation of new terms. Yes, please continue. Clause 6. We add the meaning of hotel or guest house. The new 2 capital A, meaning of hotel or guest house, mainly follows the definition of hotel or guest house under interpretation. Let me talk about the main amendments. The existing definition uses the Chinese term 旅館, and in English it's called hotel guest house. But this time around, as we said, the principal ordinance will differentiate between hotels and guest houses, and there will be 2 types of licenses. Therefore, we'd like to follow the English text more closely. Therefore, in Chinese, we will not only use 旅館 but 酒店或賓館, so that it is more clear and it is more aligned with the English text. Sorry, which text are you following? Which document should we be following? Are you using the blue bill? Yes, okay. Is it that you'd like to use another document? No, I'm just asking about the framework of your presentation, because sometimes we look at the marked up copy. But if you use the blue bill, we can use the blue bill as well. Yes, I'm using the blue bill. I am at C1485 of the blue bill.
Okay. Oh.
Meaning of hotel or guest house. As I was saying, at present, we use 旅館 in Chinese. But in future, we will change it to 酒店或賓館. And as for the implications, we are including the same elements. But now we have introduced strict liability. We are using the premises as a unit. At present, guest house will include the premises, the owners and tenants, and these are included in the definition. But now, we only aim at premises in order to decide what is a hotel and what is a guest house. Under Sec and Deputy Director, we have no members here. I'd like to propose that we do this. You are on 2 capital A. Well, I think no one has a comment on this. Let us wait till the next meeting. So when we have more members, we can continue. Shall we do that? Or shall we take a break?
Let us
take a break of 5 minutes, and then we'll whether members can come back because there is a parallel meeting going on next door.
5分鐘。
A break of 5 minutes.